francs to Celeste Arnaud, 2 billion CFA francs to Edouard Adegoke, 2 billion CFA francs to Saliou Aboudou Youssoua. On its part, the respondent state praised the court to find that in the application of 5th December 2018, the applicants seek the annulment of judgment number 2581 FD 18 of 31st July 2018. Find that the procedure relating to the appeal lodged on 2nd August 2018 by the applicants against judgment number 2581 FD 18 of 31st July 2018 is pending before Beninese courts. Find that it was heard for the first time on 15th November 2018, that is 3 months and 13 days after the applicant's lodged appeal. Find that at that hearing, the case was adjourned to 20th December 2018, owing to the formal opening of the Benin Bar Association legal year, and then to 21st February 2019. Find that the case will again be heard on Thursday, 7th March 2019. Find that the application contains clearly disparaging language directed against the Beninese executive and judicial authorities without providing the slightest proof. Accordingly, hold that the regional courts lack jurisdiction to annul domestic laws or court decisions. Hold that regional courts lack jurisdiction to issue orders to member states in respect of their domestic laws and procedures. Rule that the African court cannot substitute itself for the domestic courts to take measures failing within their prerogative in a case pending before them. Hold that the African court cannot grant the application of 5th December 2018 without interfering in the Beninese internal judicial system, thereby seriously departing from the scope of its jurisdiction. Therefore, the African court must declare that it lacks jurisdiction to hear the application filed by the applicants. Hold that filing an application before the African court is subject to the exhaustion of local remedies. Find that the applicants have not exhausted local remedies. Consequently, and pursuant to Articles 56(5) of the Charter and Rule 45 of the Rules of Court, find that the application of 5th December 2018 inadmissible for failure to exhaust local remedies. Rule that the applicant shall not, in their application, use any insulting or disparaging language against the respondent state and its institutions. Therefore, pursuant to Article 56, paragraph 3 of the Charter and Rule 40, para 3 of the Rules of the Court, find the application of 5th December 2018 inadmissible insofar as it contains disparaging and insulting language directed against the Beninese executive and judicial authorities. Reserved costs. In their reply to the preliminary objections raised by the respondent state, the applicants request the court to find that the respondent state's objection based on jurisdiction cannot succeed in law. Find that the respondent state's objections based on admissibility are unfounded. Accordingly, declare that jurisdiction, dismiss the respondent state's objection based on jurisdiction, dismiss the respondent state's objection based on admissibility, declare the application of 5th December 2018 admissible, join all objections on the merits, and order the parties to submit on the merits. In the submission on the merits, the respondent state praised the court to sustain the respondent state's preliminary objections in their entirety. Find that the violations alleged by the applicants are non-existent. Find that the applicants' claims are untimely. Find and rule that the alleged violations are pure inventions. Find that the respondent state has not violated any of the applicants' rights. Find that the respondent state has not violated Articles 6 and 7 of the Charter and Articles 8 and 10 of the Universal Declaration of Human Rights. Find and rule that judgment number 25815R of 18 of 31st 2018 was rendered in accordance with the laws in force in Benin. Find that the applicants have appealed judgment number 2581FR 18 of 31st July 2018. Find that CREATE is the competent court to hear the applicant's appeal. Hold that the African court cannot issue orders to a state to overturn a court decision or an administrative act that is allegedly contrary to the Charter. Hold that community courts lack jurisdiction to issue orders Member states, in respect of their domestic laws and procedures, find that the applicant's requests to annul the judgment and release untimely and unfounded, hold that the African court cannot annul the conviction of the applicants as it is not an appellate court of decisions rendered by domestic courts. Outright the applicant's requests for annulment of the judgment and for release from detention. Subsequently, dismiss all their requests, claims, and submissions. Order the applicants to pay all costs, including the fees of Cyril Y. Jikwi, Eli N. Vlanovu Ponu, and Charles Badu, lawyers who made the required legal representations. Operative part. For these reasons, the court unanimously on the jurisdiction dismisses the objection based on material jurisdiction, declares that it has jurisdiction on admissibility, sustains the objection based on admissibility in relation to the non-exhaustion of local remedies, finds the application inadmissible, costs, orders each party to bear its own costs. Signed, Imani D. Aboud, President, Blaise Chikaya, Vice President, Ben Kyoko, Judge, Rafa Benashu, Judge, Suzanne Menge, Judge, Marie-Thérèse Mukamulisa, Judge, Tujilane R. Chizumila, Judge, Shafika Ben Saula, Judge, Stella I. Anukam, Judge, Dumisa B. Zebeza, Judge, Modibo Saku, Judge, and Robert Eno, Registrar. Done at Arusha, this 24th day of March in the year 2022 in English and French, the French text being authoritative.
This is the decision of the court. Application number 029 of 2018, Omaru Mariko. This judgment will be delivered by Honorable Lady Justice Menge in French.
Merci, Madame la Présidente.
Thank you, Honorable President. The matter of Uma Mariko versus the Republic of Mali, application number 029-2018, judgment of 24 March 2022. The court, composed of Imani D. Aboud, President, Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benashu, Suzanne Menge, Marie-Thérèse Mukamulisa, Tujilani R. Chizumila, Shafika Ben Saula, Stella I. Anukam, Tumisa B. Sebeza, judges, and Robert Ino, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9, Chapter 2 of the Rules of the Court, Judge Modibo Sako, member of the court and a national of Mali, did not hear the application. Subject of the application, facts of the matter, the applicant avers that the 29 July 2018 presidential election in which he was a candidate was irregular. According to him, the decisions of Malian courts issued in violation of his rights, the lack of independence and impartiality of the electoral bodies, as well as the Ministry of Territorial Administration's control of the electoral process, contributed to his elimination in the first round of voting. Prayers of the parties. The applicant prays the court to find and order that the respondent state has violated his right to an effective remedy and his right to be tried by an impartial court by virtue of the constitutional court of the respondent state, his right to be judged within a reasonable time, the obligation to establish independent and impartial electoral bodies, the obligation to establish and strengthen national mechanisms to settle election-related disputes in a timely manner. The applicant also prays the court to order the respondent state to amend the organic law on the Constitutional Court to provide a legal framework for the recusal of its members ruling on electoral disputes, to amend Article 91 of the Constitution, the organic law on the Constitutional Court, and the rules of procedure of the said court, to bring them in line with Article 3 of the Charter, Article 17, Chapter 2 of the ACDEC, and Article 7 of the ECOWAS Protocol on Democracy. 3, to amend the electoral law to bring it in compliance with Article 17, Chapter 1 and 3 of the ECOWAS Protocol. Fourthly, order the respondent state to refund a sum of 25 million CFA francs paid as a deposit for the 29 July 2018 presidential election. 5, order the respondent state to pay him the sum of 100 million francs as damages for the harm suffered. 6, take all other appropriate measures for the purpose of reparation. For its part, the respondent state prays the court to rule on admissibility and to dismiss the application as unfounded. For these reasons, the court unanimously jurisdiction declares that it has jurisdiction. On admissibility, declares the application admissible, and on merits, finds that the respondent state has not violated the applicant's right to be tried by an impartial tribunal protected under Article 7, Chapter 1, Section D of the Charter. Finds that the respondent state has not violated the rights to full equality before the law and equal protection of the law protected under Article 3 of the Charter. Finds that the respondent state has not violated the right to elect and to be elected at free and fair periodic elections held on the basis of universal and equal suffrage and by secret ballot, guaranteeing the free expression of the will of the electorate, protected under Article 25, Chapter 2 of the International Covenant on Civil and Political Rights. Finds that the respondent state has not violated the obligation to establish electoral lists in a transparent and reliable manner, with participation of political parties and voters guaranteed under Article 5 of the ECOWAS Protocol on Democracy. Finds that the allegation of the obligation to establish and strengthen domestic mechanisms to resolve electoral disputes in a timely manner as guaranteed by Article 17, Chapter 2 of the African Charter on Democracy, Elections and Governance, and Article 7 of the ECOWAS Protocol on Democracy and Good Governance is moot. Finds that the respondent state has violated the right of the applicant to be tried within a reasonable time, protected under Article 7, Chapter 1, Section D of the Charter. Finds that the respondent state has violated the applicant's right to be heard protected under Article 7, Chapter 1, Section D of the Charter, and Article 14 of the International on civil and political rights by failing to respect the adversarial principle, finds that the respondent state has violated its obligation to independence of the constitutional court under Article 26 of the Charter, finds that the respondent state has violated its obligation to establish and strengthen an independent and impartial electoral body guaranteed under Article 17, Chapter 1 of the African Charter on Democracy, Elections and Governance, and Article 3 of the ECOWAS Protocol on Democracy and Good Governance. Reparations. Pecuniary reparations dismisses the applicant's request for reparation for material prejudice, awards the applicant the sum of 1 million CFA francs for the moral prejudice, orders the respondent state to pay the said sum free from tax within 6 months from the date of notification of this judgment, at the expiration of which it shall pay interest on the arrears calculated on the basis of the applicable rate of the Central Bank of West African States. Non-pecuniary reparations orders the respondent state to amend the laws governing the Constitutional Court to include provisions that ensure respect for the principle of adversarial proceedings within 1 year from the notification of this judgment. Orders the respondent state to amend the laws governing the Constitutional Court to include provisions on the procedure for recusal of judges within 1 year from the notification of this judgment. Order the respondent state to take all necessary measures to fully fulfill its obligation to guarantee the independence of the Constitutional Court within 1 year from the notification of this judgment. Orders the respondent state to take all necessary measures in any case before any election to repeal sections 27 and 28 of the electoral law within 3 years from the notification of this judgment. Orders the respondent state to take all necessary measures to fully fulfill its obligation to establish and strengthen independent and impartial electoral bodies within 1 year from the notification of this judgment. Implementation and reporting orders the respondent state to submit to the court a first report on the status of implementation of this judgment, and thereafter every 6 months until the full implementation thereof. Costs orders each party to bear its own costs. Signed, the judges aforementioned and Robert Eno, Registrar. Done at Arusha this 24th day of March in the year 2022 in the English and French languages, the French text being authoritative. I thank you.
This is the judgment of the court. The court will be reconstituted by a new bench, of which the Vice President will preside over. Thank you.
L'audience de la Cour est reprise.
Resumes.
La quatrième décision
Decision is Stephen John Rutakiki Rua,
qui sera prononcée pour la Cour
which will be delivered by Judge Chizumila.
pas autant pour moi, c'est le juge
It is Judge
Tubissa qui va
Tumisa Nsebeza.
la décision. Juge Tubissa, vous avez
So, Judge Tumisa, you have the floor.
the President and colleagues. On this, the 24th of March, 2022, the court delivers judgment in the matter of Stephen John Rutakikira versus the United Republic of Tanzania in application number 013/2016. The court is composed of Blaise Chikaya, Vice President, Ben Kioko, Rafael Ben Ashur, Susan Mengwe, Therese Mukamulisa, Jilane Chizumila, Shafika Ben Saula, Stella I. Ankam, Yunisa B. Nsebeza, Mudiwo Sako, judges, and Robert Ino, the registrar. In accordance with Article 222 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule brackets 2 of the Rules of Court, hereinafter referred to as the Rules. Justice Imani Diabot, President of the Court and the National of Tanzania, did not hear the application. I will now deal with the facts of the matter. The record before this court indicates that on the 12th of November, 1998, at 3:30 a.m., Kagera region, the applicant broke into and entered the home of Mr. Aziz Karamuna. Mr. Karamuna raised an alarm and confronted the applicant, who stepped in with a knife on both arms. The applicant tried to make away with a TV deck, 4 cushions, and a radio cassette, but was apprehended by neighbors and was handed over to the police. On 9 July 1999, he was charged before the district court at Bukoba with armed robbery. On 12 November 1999, he was convicted of the charge and sentenced to 30 years imprisonment. The applicant appealed against his conviction and sentence to the High Court, which on the 4th of March 2008 dismissed his appeal. On the 26th of May 2008, he appealed to the Court of Appeal of Tanzania, which confirmed the conviction and sentence on the 11th of November 2011. I now deal with the prayers of the party. The applicant prays the court to find that his rights were violated as alleged, to quash his conviction, and to set aside his sentence, to grant him reparations pursuant to Article 27(1) of the protocol to the tune of 5,700,000 Tanzanian shillings, and to grant him any other relief that the court may deem fit. On the other hand, the respondent state prays the court to grant the following orders. 1, that the Honorable Court is not vested with jurisdiction to adjudicate the application. That the application has not met the admissibility requirements stipulated under Rule 40(6) of the Rules of Court. That the applicant's prayers should be dismissed. That the applicant continue to serve his lawful sentences. That the applicant should not be granted reparations. That the application should be dismissed in its entirety for lack of merit. The respondent state also prays the court to find that it has not violated any of the rights of the applicant. Now, the judgment of this court then deals extensively with the jurisdictional issues. It further deals fairly extensively with whether the application is admissible or not admissible, and it traverses all of those very, very extensively. And consequently, I now deal with the operative part. All the reasons that have been traversed in the entirety of this judgment, the court unanimously on jurisdiction dismisses the objection to material jurisdiction and declares that it has jurisdiction. On admissibility, the court dismisses the objections to the admissibility of the application and declares the application admissible. On merits, the court finds that the respondent state has not violated the applicant's right to a fair trial under Article 7(1) of the Charter, as regard the Court of Appeal's assessment of the evidence. Court also finds that the respondent state has violated the applicant's right to defense under Article 7(1)(c) of the Charter is read together with Article 14(3)(d) of the ICCPR for failure to provide free legal assistance. On reparations, firstly, on pecuniary reparations, the court rejects the prayer for material prejudice. The court grants the applicant's prayer for reparation for moral prejudice suffered and awards him the sum of Tanzanian shillings 300,000. The court orders the respondent state to pay the sum of Tanzanian shillings 300,000 free from tax as fair compensation to be made within 6 months from the date of notification of this judgment, following which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. On non-pecuniary reparations, the court dismisses the applicant's prayer for the court to quash his conviction and order his release from prison. On the implementation and reporting, the court orders respondent state to submit to the court within 6 months from the date of notification of this judgment a report on the status of implementation of orders under paragraphs Roman 8 and Roman 9 of this operative part, and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, court orders each party to bear its own costs. Signed by all the judges aforementioned, Blaise Chikaya, the Vice President, Ben Kioko, Judge, Rafa Ben Ashur, Judge, Susan Mengwe, Judge, and Teresa Mukamulisa, Judge, Tujilani Chijmila, Judge, Shafika Ben Saula, Judge, Stella Yanukam, Judge, Tumisa Bin Sebeza, Judge, Mudivusako, Judge, and Robert Ino, the Registrar. This done at Arusha, this 24th day of March in the year 2022, in English and French, the English text being authoritative, I hand down the judgment.
Yeah. Decision of the court. We will now move to the delivery of the judgment in the matter related to Joseph Mukwano, a judgment which will be read by Honorable Judge Anukam. Judge Anukam, you have the floor.
Mr. President. The matter of Joseph Mukwano versus the United Republic of Tanzania, application number 021/2016, and this judgment is given today, the 24th of March, 2022. The court is composed of Blaise Chikaya, Vice President, Ben Kyoko, Rafa Ben Ashu, Susan Menge, Ed Therese Mukambolisa, Tujalin R. Chizomila, Shafika Ben Saola, Stella I. Anukam, Dumesa B. Isebisa, and Modibo Sako, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9 sub 2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, the President of the Court, and the National of Tanzania did not hear the application. Facts of the matter. It emerges from the record before this court that on the 11th of August 2003, the applicant and two others stole items from the house of Professor Israel Katutu, where they worked, and in the course of which they murdered him. On the 15th of July 2010, the applicant was sentenced to death by the High Court of Tanzania at Bukoba for the said murder. On the 7th of March 2013, the Court of Appeal confirmed the death sentence. The applicant then, on the 30th of April 2013, filed an application to the Court of Appeal for a review of his judgment. On the 28th of February 2014, the Court of Appeal struck out the application for review for being lodged out of time. A subsequent request for extension of time was denied on the 13th of March 2015 on the ground that the applicant had failed to meet the legal threshold set out by the prevailing case law. And now with the prayers of the parties. The applicant prays the court to 1, quash both conviction and sentence imposed upon him and set him at liberty. 2, grant him any other relief that it may deem fit in the circumstances. In return, the respondent state prays the court to rule that 1, the court does not have jurisdiction to hear the matter and the application is inadmissible. Secondly, the respondent state has not violated any provision of the charter as alleged by the applicant. And lastly, the respondent state prays the court to rule that the application be dismissed and the cost be borne by the applicant. The operative part of this judgment. For these reasons, the court unanimously on jurisdiction dismisses the objection to its material jurisdiction, declares that it has jurisdiction. On admissibility, the court opposed the objection to the admissibility of the application for failure to exhaust local remedies in respect of the applicant's conviction based on the doctrine of recent possession. Equally on admissibility, the court dismisses the objection to the admissibility of the application in other respects, declares the application partially admissible. On merits, the court finds that the respondent state has not violated the applicant's right to have his cause heard, as guaranteed by Article 7, sub 1 of the Charter, as regards the assessment of evidence during the domestic proceedings. The court also finds that the respondent state has not violated the applicant's rights to equality protected under Article 2 of the Charter as regards the alleged discrimination in the course of the domestic proceedings. Lastly, the court finds that the respondent state has not violated the applicant's right to equal protection of the law under Articles 3 sub 2 of the Charter as regards the alleged failure to examine evidence tendered and consider submissions of the applicants. On reparations, the court dismisses the applicant's prayer for reparation. On cost, the court orders each party to bear its own costs. This judgment is signed by this bench as earlier mentioned, including the registrar, Dr. Robert Eno, and it is done at Arusha this 24th day of March in the year 2022 in English and French, the English text being authoritative. Thank you, Madam President.
Merci, mes chers collègues.
This is the decision of the court. We'll now move to the next matter, which is Rajab Yusuf, which will be delivered by Honorable Judge Dean Kyoko. Dear Kyoko.
This is the ruling of the court in the matter of Rajab Yusuf versus United Republic of Tanzania, application number 036 of 2017. The court composed of Blaise Chikaya, Vice President, Ben Kioko, Rafa Benashu, Susan Menge, M. Teresa Mkamuliza, Fujilan R. Chizumila, Shafika Ben Saula, Stella I. Anukam, Dumisa B. Zebeza, and Modibo Sako judges, and Robert Eno registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9, Paragraph 2 of the Rules of Court, Justice Imani D. Aboud, President of the Court, and a national of Tanzania, did not hear the application. Facts of the matter. It emerges from the record before the court that the applicant was arrested and charged before the District Court of Tabora in criminal case number 112 of 2005 with the offense of rape of a 6-year-old minor. The applicant was convicted and sentenced to serve life imprisonment on 1 November 2005. The applicant filed an appeal before the High Court, sitting at Tabora, being criminal appeal number 31 of 2006, and on 27 June 2007, this appeal was dismissed. The applicant filed a further appeal to the Court of Appeal of Tanzania, sitting at Tabora, being criminal appeal number 457 of 2005. In its judgment of 28 of October 2009, the Court of Appeal dismissed this appeal in its entirety, and the applicant was ordered to pay compensation to the victim amounting to 100,000 shillings. Prayers of the parties. The applicant prays the court to restore justice where it was overlooked, quash both the conviction and the sentence of life imprisonment imposed upon him, and order his release from prison. He further prays the court to grant any other orders that may be appropriate in these circumstances. In its response with regard to the court's jurisdiction and admissibility of the application, the respondent states prays the court to order the following measures. that the Honorable African Court is not vested with jurisdiction to adjudicate on this application, that the application has not met the admissibility requirements stipulated under Rule 40, Paragraph 5 of the Rules of Court, that the application has not met the admissibility requirements that the application be declared inadmissible, that the application be dismissed. With regard to the merits of the application, the respondent state prays the court to order the following measures: that the government of the United Republic of Tanzania did not violate the applicant's rights provided for by Article 2 of the African Charter on Human and People's Rights, that the respondent state did not violate the applicant's rights provided by Article 3, Paragraph 1, subparagraph 2 of the Charter, that the respondent state did not violate the applicant's rights provided under Article 7, Paragraph 1 of the African Charter, that the respondent state did not violate the applicant's rights provided by Article 7, Paragraph 1, subparagraph C of the Charter, that the respondent state did not violate the applicant's rights provided for under Article 107A, Paragraph 2, subparagraph B of the Constitution of the United Republic of Tanzania of 1977, that the application be dismissed in its entirety for lack of merit, that the applicant's prayers be denied, that the applicant be ordered to pay the cost of this application. Operative part. For these reasons, the court unanimously, on jurisdiction, dismisses the objection to material jurisdiction, dismisses the objection to temporal jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection based on non-exertion of local remedies by a majority of 9-4 and 1 against. Justice Shafika Ben-Saula finds that the application was not filed within a reasonable time within the meaning of Article 56, Paragraph 6 of the Charter, and Rule 40, Paragraph 6 of the Rules, declares that the application is inadmissible, and on course orders each party to bear its own costs. Signed by the judges that I read at the beginning of this ruling, in accordance with Article 28, Paragraph 7 of the protocol, and Rule 70 of the rules, the declaration of Justice Shafika Ben-Saula is appended to this judgment. Done at Arusha this 24th day of March in the year 2022 in English and French, the English text being authoritative.
Merci, honorable doyen. Quelle est la décision?
This is the decision of the court. We'll now move to the next matter number 7, which is the last matter. Matter Almas Mohammed and others, and this will be delivered by Honorable Judge Shafika Ben-Saula. Over to you.
The matter of Almas Mohammed, Muwinda and others versus United Republic of Tanzania, application number 030/2017, judgment 24 March 2022. The court, composed of Blaise Chikaya, Vice President, Ben Kyoko, Rafa Ben Ashur, Suzanne Menge, M. Therese Mukamolisa, Tuzilan R. Chizumila, Shafika Ben-Saula, Stella I. Anukam, Dumisa B. Nsebeza, Mobi Dosako, judges, and Robert Eno, registrar, in accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabud, President of the Court and a national of Tanzania, did not hear the application. Facts of the matter. It emerges from this record that through a government notice dated 21 March 1997, the respondent state dissolved Rafiki Textile Mills, hereinafter referred to as UTM, a public company, and retrenched all the applicants. All the applicants received letters which indicated that the effective date for the termination of their employment was 31 March 1997. As part of UTM's dissolution, all its liabilities were vested in the respondent state's treasury registrar, and these included those pertaining to employees' terminal, retirement, or similar benefits. Due to disagreements about the timing of the payment of the applicant's terminal benefits, 105 former employees of UTM, inclusive of the present applicants, brought a civil suit, civil case number 394 of 1998, at the High Court in Dar es Salaam, seeking the payment of subsistence allowance for the time they had been awaiting payment of their terminal benefits. On 12 July 22, the High Court found in favor of the applicants and ordered that they be paid subsistence allowances at the rate of Tanzanian shilling 6,400 per day from the date of refreshment to the date of the High Court decision. On the respondent state's appeal to the Court of Appeal, it was held on 30 May 26 that the subsistence allowance due to the applicants was only up to the date when they actually received their terminal benefits and not up to the date of the judgment of the High Court. In each judgment, the Court of Appeal found that the applicants' terminal benefits were paid in 3 batches, that is on 30 April 1997, 31 May 1997, and 31 July 1997. It thus ordered that subsistence allowances be paid to the applicants for the period between the date of their termination of employment, 31 March 1997, and the date on which their terminal benefits were actually paid. The applicant filed an application for review of the Court of Appeal's decision on the ground that it had an error on the face of the record, but this was dismissed on 2 September 2008. Subsequently, the applicant filed an application for extension of time to file application for review of the Court of Appeal's decision on 2 September 2008, but it was dismissed on 7 August 2017. Prayers of the parties. The applicants pray that since they are victims of the violation of human rights done by the respondent state, then it is prudential and reasonable to order the respondent state to pay subsistence allowance to the applicants and other forms of reparations as this honorable court may deem fit and just to grant for the sake of justice. Specifically, the applicants pray that the respondent state pay them their subsistence allowance to the fund of shilling 6,400 a day from 31 March 1997 to the finalization of the dispute. The applicants further pray that the court makes an order to the respondent state to pay interest at commercial rate, cost of this application, or any other orders for reparation of the applicants for the interest of justice thereof as this honorable court may deem fit and just to grant. It is also the applicant's prayer that the respondent state should also be ordered to report back to this honorable court every 6 months until they satisfy the orders this court shall make when considering the submission for reparations. According to the default of the respondent state, the court decide to order on default decision. About jurisdiction, after deliberation, the court decide that it has material jurisdiction, personal jurisdiction, temporal jurisdiction, and territorial jurisdiction. About the admissibility, after deliberation, the court decide that the application is admissible. About the merits, the court, after deliberation, dismissed the allegations. Operative part. For these reasons, the court unanimously on jurisdiction declares that it has jurisdiction, on admissibility declares that the application is admissible, on merits finds that the respondent state has not violated the applicant's right to work under Article 15 of the Charter, finds that the respondent state has not violated the applicant's right to non-discrimination under Article 2 of the Charter, on the reparations, dismisses the applicant's prayer for reparations, on cost, orders each party to bear its own cost, signed by the president, the previous branch. Done at Arusha this 24th day on March in the year 2022 in English and French, the English version being authoritative.
La décision de la Cour. Avant que
Decided. Before we adjourn our session on behalf of the court and the President, Honorable Imani Aboud, we would like to salute the members of the court of Wemu who have been present here at this sitting. Thank you very much. Thank you to you all.
May I request that you place the interpretation equipment in the pocket in the back of the seat before you. There is a pocket before you. Place the equipment in that pocket and